時間到啦。
It's the appointed time. We have a quorum. I call to order the meeting of the panel on commerce, industry, and innovation and technology. The first agenda item is information papers issued since the last meeting. Since the last meeting, the Secretariat has not issued any information papers. Agenda item number 2, schedule of meetings for the remainder of the 2025 session. I would like to draw members' reference to the proposed schedule of meetings before you, members. So we have dates of 15th of July, 16th of September, and 10th of October. The meeting of October was supposed to be held on 21st of October, but in accordance with Section 6.3 of Chapter 542, the Legislative Council Ordinance, to enable a LegCo general election to be held, the Chief Executive may, before the end of a term of office of the LegCo, prorogue that the Council is to terminate its operation. As the date 21st of October may be close to the date on which the Council terminates its operation, we should probably move the date up to 10th of October. If members have no objections, the meeting will be held on that day at 10:45. Agenda item number 3. Items for discussion at the next meeting. The next regular meeting is to be held on 20th of May. Let me also say this, for dates of other meetings, they have not been changed except for the one in October. The administration proposes to discuss 2 items. 1, latest developments of new industrialization in Hong Kong. 2, pilot INT accelerator scheme. Do members agree to discuss the 2 items on 20th of May at the meeting of the panel? If there are no objections, we'll move on to the next agenda item. Agenda item number 4, proposed subsidiary legislation for specification of libraries, museums, and archives and prescribed conditions for certain permitted acts under the Copyright Ordinance. Welcome, Undersecretary and other government officials. Members who would like to speak, please press the request to speak button. Dr. Bernard Chan, when you're ready, please brief members on the paper. Sure, Chair. Thank you, members. Today, together with colleagues from the IPD Intellectual Property Department, will brief members on proposed subsidiary legislation for specification of libraries, museums, and archives and prescribed conditions for certain permitted acts under the Copyright Ordinance. In line with the government's policy, we are committed to ensuring that Hong Kong's copyright regime can safeguard the legitimate interests of copyright owners while also serving the public interest. We want to strike a proper balance to make sure we can continue to safeguard the sustainable development of creativity and copyright development. We are to promulgate subsidiary legislation under the Copyright Ordinance. We want to prescribe some conditions as well as make specifications for relevant bodies. We also want to phase out the Copyright Libraries Regulations Chapter 528B, which is outdated because it was enacted in 1973 and it cannot accommodate the Copyright Ordinance's sections 47 to 53 for some permitted acts. We want to make sure the provisions will be up to date and provide a framework to support libraries, museums, and archives to properly use copyrighted works. From February to April last year, we consulted the public through different channels. We received 14 submissions from IP practitioners, groups, industry stakeholders, as well as some submissions from the library, museum, and archive sectors. Respondents generally welcome the government's proposals. They also welcome our legislative proposals. Some respondents also provided suggestions, and we have incorporated such suggestions, enhanced our proposals so as to properly implement our policy intent. We're working with the Department of Justice to draft the relevant subsidiary legislation. We aim to introduce into the Council the proposed subsidiary legislation for negative vetting. I will then ask the Deputy Director of Intellectual Property to brief members on the legislative proposals available during consultation and the submissions received. We would welcome members' feedback. In the near future, we will continue to maintain communication with stakeholders. Thank you, Chair. I'll now pass the floor to Mr. Thomas Tsang, Deputy Director of Intellectual Property. Sure. Mr. Thomas Tsang, please. Thank you, Chair. Good afternoon, members. I would like to brief members on our draft legislative proposals, our consultative process, and the specific provisions. Under the existing copyright ordinance, it provides protection for copyright. It lays the foundations for creativity, but it is not an absolute right. We need to serve also public interests. Right now, there are 60-odd provisions. Deputy Director of Intellectual Property, we already have the paper before us. You do not have to read everything. You can just talk about the salient points. All right. So the first slide is about some background information. We are trying to strike a balance, and the draft proposals are in line with international standards. And of course, in the PowerPoint presentation, we also have some justifications that we would like to quote. And specifically for the sections 47 to 53, they provide for permitted acts which specified libraries, museums, and archives may do. The Copyright Amendment Ordinance 2022 came into effect in May 2023, and the ordinance extended the statutory application of certain permitted acts for specified libraries and archives to specified museums, and introduced and expanded certain permitted acts for specified libraries, museums, and/or archives. As the Undersecretary said, we have Chapter 528B, the Copyright Libraries Regulations, that is effective at the moment, but the provisions are outdated. They were supposed to be transitional provisions, yet they remained applicable. They cannot accommodate for the permitted acts in sections 47 to 53 of the Copyright Ordinance. It has caused inconvenience to users. We consider there is a need for a comprehensive review and bring updates to the provisions. Now, the Secretary for Commerce and Economic Development is empowered to exercise the statutory powers under Section 46 of the Copyright Ordinance to promulgate subsidiary legislation for permitted acts under Sections 47 to 53. That would include to prescribe some conditions as well as provide specifications of libraries, museums, and archives. On public consultation between February and April last year, we published a consultation paper that includes the detailed legislative proposals. For example, the prescribed conditions and specification provisions that would be the proposed descriptions of specified libraries, museums, and or archives. We have consulted some professional groups such as IP practitioners groups as well as sector stakeholders such as the library, museum, and archive sectors representatives. We have received in total 14 submissions from different sectors, as you can see here. In general, as the Undersecretary said, the respondents welcome and supported the government's legislative proposals. Some respondents provided technical suggestions on the issues for consultation. We have thoroughly considered the suggestions and have incorporated some. We had some exemption provisions. For example, we would say if libraries, museums, and or archives are conducted not for profit, they will be exempted, or if their collection is generally available to public or accessible to the public, these will also be exempted. We heard the sector's feedback. The stakeholders considered the original proposed definition would be too restrictive if we are to specify also the owners of the specified museums, libraries, and or archives. Therefore, we propose to amend the definition to say instead that it will be determined based on the facts and circumstances of each case, in particular the basic nature and actual operation of the relevant library, museum, or archive. As for the other part, collection generally accessible to the public, the sector's feedback is that with the current or with the proposed definition, it might exclude libraries, museums, and or archives that mainly serve a section of the public or some of the stakeholders. So we propose to amend the definition to say the public or a section of the public. Section 48 of the Copyright Ordinance provides for some technical specifications. It includes an interpretation for a reasonable proportion of a work. We have considered existing subsidiary legislation and the practices in overseas jurisdictions. We had a draft proposal of the threshold being not more than 10% of a work to be regarded as a reasonable proportion of the work. The sector's feedback is such. they want us to provide some guidelines as to the applications of the 10% threshold. We want to adopt a more flexible approach. Again, we want to have regard to the facts and circumstances of each case. We also will have regard to the nature of the work, say if it is an audio recording or if it is a movie or literary work. And then we will set a ratio, for example, word count, number of pages, or the playtime.
Under Section 51 of the Copyright Ordinance, there is a term, permanent collection. There isn't a legal definition for this term. We think if there is an interpretation for the term, it would be better for users. We refer to collection of cultural or historical significance or importance when we refer to permanent collection, and they cannot be borrowed by users easily. They're usually for on-the-spot reference. We have taken into consideration permanent collection on loan between libraries, and we think it is appropriate to include not only collection of cultural or historical significance, but also collections that are kept permanently by libraries, museums, or archives. We refer to specific permitted acts in the provision. And permitted acts could be done if they are for research or private study. And if permitted acts could be done, we allow libraries or relevant museums to reproduce the relevant works. And if they want to do that, they'll have to make or sign a declaration. Say, for example, if a library wants to reproduce a copy of a certain work, then a declaration will have to be signed. And originally, we wanted to ask libraries to come up with their own declarations, but after collecting their views, we found that libraries are of the view that it will be very helpful if we can come up with a sample declaration. So in the subsidiary legislations, we will prescribe a declaration form for relevant users. That's all from my briefing. We welcome any questions from members. Thank you. Thank you, Mr. Deng. Now I'll open the floor for questions. The following members have pressed the request to speak button. They are Mr. Martin Liao, Mr. Robert Lee, Dr. Wendy Ho, Mr. Jimmy Ng, Professor Priscilla Leung, and Professor William Wong. Mr. Martin Liao. Thank you, Chairman. I'm glad that Deputy Director talked about some guiding principles on copyright as well as patents. The guiding principle is to encourage creativity and to serve the public interest. They have taken into consideration anti-monopoly as well as market behavior and so on. I'm happy that the administration had come up with these guiding principles as it tried to come up with the subsidiary legislations. According to the document, those who reproduce copies of certain works will have to make or sign declaration. And one has to make sure that they had not obtained the relevant copies before. There are views that for primary school and secondary school libraries, students might make copies of examination questions for study purposes. There is usually one librarian to manage school libraries. There won't be staff dedicated to check whether students have signed the relevant declarations, so in actual operation there might be difficulties. Has the government come up with guidelines so that the ordinance could be complied with by the relevant stakeholders in actual operation? Deputy Director. It is mainly librarians as well as staff members of museums and archives who can make reproduction of copies. For other users, they will be regulated by the subsidiary legislations if they want to make a reproduction. And this legislation will not cover users who want to make copies on their own. Now, the subsidiary legislations only regulate the permitted acts of libraries, museums, and archives. For users, there are exempted acts under the ordinance. For example, if the user studies certain subjects in a school and he has to, for research or study's sake, make use of copyright works, users may be exempted. On law enforcement, we don't see that there will be abuses of the exemptions or the ordinance. The Education Bureau has, on behalf of schools in Hong Kong, obtained copyright licenses from copyright owners. For example, certain works are being made use of as teaching materials, and currently we don't see any problems with using these copyright works. We will keep in close communication with relevant stakeholders and we will listen to their views on a continuous basis. I don't think the Deputy Director understood my question. I have a follow-up question. Say a student wants to make photocopies of certain copyright works. The students won't have the right to do so, is that right? Let me clarify. This legislative proposal covers the acts of libraries, museums, and archives. I understand, but if a student wants to make photocopies, it will be the library that applies for exemption, not the student himself, right? Who will be the user in the example I raised? It will be the student or the library user. So what will be the student's responsibility in this case? Take libraries as an example. Libraries sometimes offer photocopy machines. Understand that there's usually a copyright notice near these photocopiers. These notices tell students not to make photocopies of an entire publication, for example. What I want to say is that there are certain exemption clauses under the copyright ordinance, and these clauses benefit students who want to make use of copyright works for research or study purposes. And under these provisions, students can make photocopies of copyright work. Well, I don't understand what the Deputy Director is saying. Well, this is a very good question, Mr. Liao. I believe students would be very curious about this. I understand that there might be guidelines or notices put up near the photocopy machines. But students might breach the law inadvertently, and we don't want this to happen. You keep telling us what possibilities there might be, and we want to avoid these possibilities. We all want to abide by the law. How can you prevent students from inadvertently breaching the law? You were quite vague just now. Library users include students as well as other staff members. Say a student enters into a library and he wants to make photocopies of exam questions to prepare for his exams. What will be the student's responsibility? Is that Mr. Liao's questions? Yes. Well, according to your document, you said those who obtain the reproduction have to make or sign a declaration. Chairman, I wasn't being clear enough. Say a student requests the library to provide photocopies. Well, if the photocopying act is carried out by the library, then the declaration would come into play. That is, the student will have to sign a declaration declaring that he does not have in hand any photocopies of the copyright work, and the photocopy obtained will be used for study purposes. If the library can, then the library will make photocopies of the relevant copyright work for that student. Well, what Mr. Liao was saying is that under some circumstances, students might have taken some books from the library shelf, and the books might be helpful for, say, their project or research. They might not necessarily need the library to do the photocopying for them. And they might obtain photocopies by making photocopies through the photocopying machines in the library. What I said was that we try to strike a balance between safeguarding copyright as well as serving the public interest. Say a student only needs a few pages of a book for his homework, not the entire book. Chairman, indeed, I don't think the Deputy Director understood my questions. I asked what happened or what would happen if the student asked the library to make photocopies for him. Will you ask the student to sign the declaration? Well, my question is that if a declaration has to be signed, there might not be enough staff from the school library to monitor whether every student would sign the declaration. I'm not saying that students would make photocopies themselves. I'm asking about how the library would be able to monitor the student's signing of declaration. Would alternative arrangements be made if there is no sufficient staff to monitor the signing of declarations of students? Well, if Deputy Director, you still do not understand the questions, please provide a written reply after the meeting. I think we need a clear reply from the administration on this question. We have to clarify what needs to be done if photocopies are made by different parties. If there is no sufficient staff, students might make the photocopies themselves. Chairman, could I supplement? Yes, Andy. Well, let me try to address the questions raised by Mr. Liao. Normally, there are two types of collections in school libraries. Collections on bookshelves, that is, any user can make photocopies of these books. Say you are interested in particular pages, you can make photocopies of the book. For this type of collection, if they are not covered under sections 47 to 53 of the Copyright Ordinance because these sections refer to the permitted acts of libraries, museums, and archives. In the circumstances you raised, we have to rely on the over 60 provisions under the Copyright Ordinance. We have to rely on users to ensure a fair and equal treatment. That means there is an exemption for educational use. Well, it's clear now.
跟住係李慧宏議員。
Mr. Robert Lee. Thank you, Chair. Copyright protection is very important for investors, entrepreneurs, or R&D teams. Once they have poured time and money into something, we should protect their creativity and inventions. Today, we are talking about legislative proposals for specification of libraries, museums, and archives and prescribed conditions for certain permitted acts under the Copyright Ordinance. I understand the need for changes to be made because certain provisions are outdated. With the development of AI and it getting more prevalent, how many of your provisions, or have you considered at all accommodating the use of AI? We have seen examples in different parts of the world, such as for papers or research publications. The copyright owner may not have had their copyright infringed directly, but when the AI crawls for data and found the relevant works or publications, the AI tools will crawl through such works with copyright without pretty much any regard for copyright. So what is going to happen with the proposals in place? Will the provisions tackle this issue? Thank you. Andy, Deputy Secretary. Thank you. In February, we actually made a report on copyright ordinance on data mining. The target for the relevant proposals is the same as these, to make sure adequate protection is offered to copyright owner. And when possible, make the work available for use with some agreements in place. If there is no agreement in place, then we may allow non-commercial research uses. But there are some conditions. The copyright work must be obtained legally. The work cannot be used in data mining, and the relevant company must keep what kind of works or what works have been used in their training of the AI tools. Once the conditions are met, then they can use such works. And we were very glad to have the support of the panel. Therefore, we are drafting the bill right now, and we will submit the relevant proposals in due course. But these will come separately from what we have here today. Thank you. Dr. Wendy Hung. Thank you. I support support the proposed subsidiary legislation for R&D staff, students, or the general public. Copyright works are an important resource, and having a set of reasonable rules to use the copyright works would be ideal. I do have some questions on some details. I want to ask about Annex 3, Section 47. So in A1, it says particular. Persons requesting for copies must make and sign a declaration to satisfy the librarian that they require the copies for research or private study and will not use them for any other purposes. So there are people who may have used the copies for research purposes. If they, in the end, profit from such research, will they have considered to have breached the relevant provisions? Also, it is said in B, no person is furnished with more than one copy of the same article or with copies of more than one article contained in the same issue of a periodical. So there are more than one article in a periodical. So does that mean one cannot copy more than one article in a periodical, or do you mean otherwise? I also want to ask that for some particular provisions, it says only a reasonable proportion can be provided. For example, in Section 48. So with the reasonable proportion, is it the same for AI training? We can only provide a reasonable proportion of the work for the training of AI. Deputy Director of Intellectual Property. I think we have to refer to the Principal Ordinance because the Principal Ordinance already spells out the restrictions. For example, the use of copyright works for research or private study. We have already some restrictions in the Principal Ordinance, some conditions. So the subsidiary legislation basically reflected what is said in the Principal Ordinance, that it must be for research or private study purposes. When it is said that no person is furnished with more than one copy of the same article or with copies of more than one article contained in the same issue of a periodical. This is also a condition set out in the Principal Ordinance, and we are just repeating the requirement here. The principle is this. For the article, if one has to be furnished with an article, then the declaration would come into play. Say for students, they do not have a copy in the first place. Then the library can, subject to the conditions, provide the student with a copy of an article. But if the student wants an article in a periodical, and as the members said, there are multiple articles in a periodical, then the student cannot obtain more than one article contained in the periodical. Again, this is a requirement in the Principal Ordinance. The member also mentioned the issue with training of AI. Research or private study, this expression has quite a broad scope. For the training of AI, does it count as research or private study? It is what is relatively vague in law. So, as the Deputy Secretary said, when we made our report to the panel in February, we plan to provide some exemptions for the training of AI, but there are some conditions. And if the conditions are met, it will not be considered as copyright infringement when training the AI with copyright works. I think different professions have different practices, so I hope my answers can answer the questions made by the member, Mr. Jimmy. We now have a threshold of reasonable proportion being not more than 10%. There is some flexibility. If necessary, it can go beyond 10%. But is it possible, say, for different libraries, university libraries, or general libraries, there may be different thresholds adopted for the 10%. So how can people know how much of a work one can get when they make a copy at a library? Would you ask libraries to provide lists for easy reference of the public or users? Who is going to answer these questions? Deputy Director of Intellectual Property. For the interpretation of a reasonable proportion of a work, we want to be more flexible, and the threshold of not more than 10% of a work is just for illustration purpose. And it may be the case that different libraries, museums, and archives may have different judgment as to where the threshold lies. Regardless, one has to be reasonable. After all, it is about a reasonable proportion of a work, the threshold. So it would be on a case-by-case basis. It would have to have regard to the nature of the work and whether it is a reasonable proportion. When we talk about the 10% threshold, it is, as I said earlier, just for illustration purpose. Some called for 10% being a maximum threshold, and in some overseas jurisdictions they have practiced this, say in Australia and Singapore. This is their interpretation. But having regard to local circumstances, and we want to facilitate research and private study purposes, we will adopt the threshold only as illustration. We want to provide flexibility for different use cases. For different uses in libraries, museums, and or archives, after the subsidiary legislation has been passed under negative vetting, we will make sure to enhance awareness of users and the relevant sectors, and if necessary, we will promulgate guidelines to facilitate the implementation of the provisions. Chair, I'm asking what happens for the part exceeding 10%. So say for a student going to the Chun Wan Public Library to make a copy of a work, it should be the same for what they can get in Chun Wan Library in, say, Central Public Library. If people can get different proportions at different libraries, what will happen? So if you think it is reasonable and the students can go to, say, 10 different libraries to get the whole work, right? How can you prevent that from happening? Deputy Director, Well, you don't have to talk about the provisions. I think it's very simple, the question. So people can just go to 10 different places and obtain the whole work, right? Well, we actually have a declaration requirement. If students want to obtain copies, they need to sign a declaration to not only say they are requiring the copies for research or private study, and they have to make sure they provide statements of truth in the declaration. Chair, he's not answering my questions. They can just say they are still for research or private study, and they are just obtaining 10 pages of the work, but the declaration does not spell out one breaches the law if you obtain more than 10% of the work, right? Chair, you understand my question?
我哋要啲
Well, you can ask students to sign declaration forms. I think students are, in general, very honest. They usually ask for photocopies based on their needs. Well, the question asked was very simple. You said 10% is a reasonable threshold. Say I want to get copies of an entire book. I just need to go to 10 libraries. So how will you deal with such situations? Well, we ask that students exercise self-discipline. I think the member was referring to an abuse case. Well, if I go to 10 libraries to get photocopies of an entire book, it's legal. Well, we have to look at whether there's a genuine need for the students to get photocopies of the entire book. We want to facilitate students' research as well as private study. That's the original goal. I don't think members here are happy with the answer. Let's not look at this in a negative perspective. Anyone can make or can get a copy of 10% of the work. Well, I believe most of these people do it for research purpose. But the truth is, Hong Kong is a small place, and it's easy to take public transport in Hong Kong. So it's very easy for you to go to 10 libraries to get photocopies of an entire book. Well, it might not be practical for librarians to explain all these rules, and you ask users to sign a declaration. Well, after the declaration is signed, who will be responsible for following up on the declaration? Well, I see that Andy is eager to answer the question. Well, Deputy Director was trying to address the question. Well, to be frank, we saw stationery shops making photocopies for entire books for students, and they didn't need to sign declarations. This is not what we want to see now. The goal of the copyright ordinance is to safeguard the interests of copyright owners. Say a student needs the content of an entire book. Our suggestion is to ask the student to buy a book instead of getting 10% of the copies of the book in different libraries. We have to educate our students so that they respect our intellectual property. What Deputy Director didn't say is that there's a plan for the Intellectual Property Department to go to different schools to stage drama performances as well as talks so that students have the awareness to respect intellectual property and that they know what they should do and what they should not do. After the enactment of the legislation, we will educate students when we go to schools to tell them what is the reasonable proportion of the copy to be made and so on. Well, you have to step up publicity. Secondly, on implementing the law, I think you have to explain to the public how you're going to enforce the law. Well, the example raised by the member just now could happen anytime. We don't want to see laws that are hard to be enforced, so I do hope that you can provide supplementary information after the meeting. Yes, Professor Priscilla Leung. Well, what we talked about just now, it's very common in universities. Sometimes there are no extra editions of a book or no more publications or no more copies available. So it's hard for students to buy the book they want sometimes. And whenever I try to give my copy to my students, they told me that there is a restriction on the proportion of a work that they can get. My experience is that libraries rarely make photocopies for students. You make photocopies on your own by using the photocopy machines in libraries. Just now you said students should exercise self-discipline. Well, I think we can only rely on the self-discipline of students then to facilitate research or private study. Well, I think it really depends on how much students or scholars respect the copyright of other people's work. Well, what I want to say is, first, this is hard to be implemented. Say a copyright work is used for a non-commercial purpose, I think the 10% threshold is rather low for the reasonable proportion of a work. Say for teaching materials or for textbooks, we make photocopies for one chapter for each lesson, or one chapter per week. And it's hard for us to calculate whether the 10% threshold is exceeded. So are you going to ask libraries to do sampling checks or surprise inspections? Well, students will be under pressure to exercise self-discipline, but I think you can consider making sampling checks or surprise checks. Now, I sometimes got complaints saying that different musical work is combined into one new piece of work. And different composers are involved. That means different copyright owners are involved. Is it a case that cannot be dealt with by the existing ordinance? Say I copy a certain part of different work, and how can you initiate prosecution in this case? Perhaps teachers can sit together and form a committee to tell people that this isn't right. Well, this is because with AI, this kind of copying can be done easily. This is a very good question, and this question is related to the previous question. Well, we have the law, we have people who enforce the law, but we also need a mechanism under which the government can carry out or different stakeholders can carry out surprise checks. Now, on this question raised by Professor Leung, who will take the question? Chairman, I thank Professor Leung for the question. Let me address the question about AI first. In our public consultation on AI, we also talked about what we should do to tackle generative AI. According to the feedback we got, under the existing legal framework we have, we can deal with any issues that arise from generative AI. Say a piece of work is protected by copyright and the work is being reproduced. You don't have to reproduce the entire work, just some parts of the work without permitted acts or without permission. It is infringement of copyright under our ordinance, and there is civil liability under this situation. As to how we will enforce the law, we have to look at the work itself generated by AI. Can we tell that it is a copy of a major part of a work? We'll have to rely on the copyright owner to give evidence. And through legal means, the copyright owner concerned can ask for compensation from the person who copied the work. Well, before I invite the next member to speak, well, the reply from the administration today is rather complicated. Well, it is a straightforward issue, but the reply seems to be very complicated. Well, we're supposed to end this meeting at 3:30, so I'll first extend this meeting by 15 minutes. Next member to speak, Professor William Wong. I'd like to offer some suggestions. On the questions we touched on just now, the government is trying to build smart libraries. Have you thought of making use of NFT or blockchain technologies to ensure that each person can only get one copy? There should be tools to support how the copyright works are used. Say you go to the Tsim Sha Tsui Library or the Mong Kok Library. With NFT, you can register the original copy, and also through the tool, you can prevent a person from making more than one copy. Secondly, I think we can look at the discussion we had just now in two levels. We always focus on the original copy in libraries. As to how the copies or photocopies are combined, well, the user should be responsible for the act. If you're worried that a work is copied too many times, this should be a problem being studied by the government. But I don't think you should worry too much about photocopies being combined. Also, I think you should think about the different versions of works. In museums and libraries, there are old electronic versions of the collection, and they get too old that they aren't readable by users or readers. How can you ensure that users or readers can get or can have access to very old e-copies of library collections? I think this is a valid question. Say there are many chapters in a book, and making photocopies of these chapters is an act of individuals, and I think it's too complicated to enforce the law in this sense by checking how many copies each person has made. Say a student tries to mix the different copies of different books together. I think it should be up to the university to regulate such act. Yes, please address Professor Wong's questions. Say, I've got a piece of work here, and we take this piece of work as a unit. The permitted acts are for individual units. Well, can you reply the question in a more humanized way? I understand the laws are written this way. Well, my question is, you have set the 10% threshold. Well, I think 10% is too low. Now, the question is, someone makes a lot of copies or make multiple copies of a book. That would be a problem. Well, since you're going to build smart libraries, will you make use of NFT or blockchain technologies to address this question? Say I can go to 3 different libraries to get copies of different parts of a book, then you won't be able to address this question. Well, we are heading towards smart libraries. Why don't you bring in technologies like blockchain or NFT which can help you?
但係有呢啲咁
We do understand what you're saying, and the member has already made a suggestion. How will you deal with the situation? I understand in implementation how we can prevent abuse. I think there are different solutions that libraries can implement, such as technical solutions like those using blockchain technology to monitor the user's records of making copies. This is a way for libraries, museums, and or archives to regulate users' acts. But this is not the point of these proposals. We are just providing for a framework outlining the principles. As for how we can prevent abuse in libraries, museums, and or archives to achieve policy intent, we can liaise with sector stakeholders to make sure we can implement the provisions properly. We will try to pick their brains and get their suggestions as well. Deputy Director of Intellectual Property, we're not rubber stamps. We need to understand what the legislative proposals are and consider the proposals. I think the member's suggestion is very much valid, so you should consider the suggestion. And you should probably promulgate guidelines for implementation to deal with the different possible scenarios. Having heard the suggestion, I think you should convey to the stakeholders and promulgate guidelines for implementation. I very much agree, Chair. You said you're just providing for a framework, but libraries have to implement the provisions and you're just leaving them to their devices. It is not responsible. You need to think about the different stakeholders to make sure you can implement the provisions properly. Actually, as the Deputy Director said, we are providing for a framework, but we will have different aspects of work following the coming into effect of the subsidiary legislation. We have publicity and education, and often it would be on a case-by-case basis. As said, I think we will promulgate guidelines in future to facilitate the implementation of the provisions. Mr. Holden Chow, I have only 2 suggestions. One of them is, as many members said, for the 10% threshold. It is important in implementation. How can you achieve your policy intent? So say if one goes to various libraries to obtain different parts of a work, it's hard for you to prevent that. And if one is using it for other purposes, who is going to find out about it? Who is going to regulate that? Are you asking university to do that? I believe the submissions are submitted. One of them is submitted by the Joint University Librarians Advisory Committee of the HKSAR. I think you are basically shifting the responsibility onto universities, but then universities may think this is additional work for them. Can they really follow up with every one of their users to make sure they are using such works for research or private study purposes? I think it's unfair if you're shifting the responsibility to universities. If it is that difficult to implement, do we really need the provisions? This is just my comments. I do understand the purpose of the subsidiary legislation. For example, you are providing for remote access of aged documents that are not suitable for borrowing on a routine basis. And I would agree because some of these publications are fragile. And with developments in technology, I think we should facilitate remote access. However, I think while the framework does have some pros, there are definitely cons. And one of the cons is the difficulty in implementation, and essentially you have shifted the responsibility to management personnel of the libraries, museums, and archives, as well as universities. I think that's very unfair. If you need time, I'll give you time for you to prepare your answers. I will ask the Deputy Secretary to answer the questions. Thank you. We will, of course, liaise with libraries on our latest situation of the proposed subsidiary legislation. After all, they are stakeholders, especially for their precious collections. For, say, permanent collections, actually, we do have some provisions touching on them that they should, when they have cultural and historical significance, and they may be on loan from other libraries, that may be lost. We often have such publications not available for the public for their copy making at any time. They are often kept, say, at the back room of libraries, and librarians would have to make copies for users. So if the books are so fragile that if they are taken out even once or twice, they may be damaged. We, of course, want to facilitate remote access, and we would encourage libraries to do so. We talked about how to prevent abuse as well. If the publications are managed by librarians rather than being available off the shelf, I think such collections should not be prevalent in the library system. In Hong Kong, it may only be available in 1 or 2 libraries, so I think it would be the case that it would be easier to manage. Thank you. Mr. Dennis Leung, I understand the need to update outdated provisions, but I think even with the proposals they have at the moment, we are still not catching up. The provisions are only applicable to, it seems, non-electronic publication. I think there are some loopholes already that members have identified. For example, people can copy different parts of a work at different places to obtain the whole work. But I am most concerned about a part that was from feedback from relevant bodies. That is, you have removed or added an expression for declaration for copyright protection. But if people sign declarations for, say, any unauthorized reproduction, communication, or dissemination which does not fall within any statutory provisions of permitted acts may constitute copyright infringement. It can have unintended consequences in court. If we do not have clarity on the scope of copyright protection and legal consequences for future copyright owners, can they go to the different libraries, museums, and archives to obtain records of users who have made copies? Should there be uses outside research or private study? Will the users be made liable? Can that be an issue? I don't think the paper touched on this scenario. We have many publications and documents available electronically, and if the declarations are available electronically, it may be easy to identify the users, and the users may be accused of copyright infringement easily. So I think we need to be very careful with the use of declarations. I will only give you 2 minutes to reply to the questions because our meeting is supposed to end at 3:45. Thank you. The declaration is to grant an exemption for the users to make copies, and the users should spell out specifically their uses in the declaration. We heard feedback that if we are to add some contents in the declaration telling users that the use has to be reasonable, that is, you're only using a reasonable proportion of the work, for example, that one should not make a copy of an unreasonable proportion of the work. This is just a reminder, and we are to strike a balance for copyright protection only. Thank you, Chair. I think our discussions are very fruitful today. I understand that the administration plans to submit the subsidiary legislation to the Council in Q2 of this year for negative vetting. Let me first ask if members support the legislative proposals. All right, members support the proposals, but of course, members raise various concerns. I hope that the administration would note such concerns and take follow-up action. The suggestions of members are very good. we of course need to make sure we're dealing with the different possible scenarios to make sure the legislation is comprehensive. I thank the administration's representatives for attending this meeting today. Let's move on to the next agenda item. Do members wish to propose any other business? If not, meeting adjourned. Thank you.